Garcia. I'm the paralegal here at Soberalski Immigration. Today we're going to talk about U visas, T visas, and VAWAs, all victim-based applications. The Victims of Trafficking and Violence Protection Act of 2000 authorized two new visas, the U visa for immigrant victims of serious crimes and the T visa for victims of severe human trafficking. These visas were created due to rising public safety concerns, with the idea that foreign victims of crimes in the U.S. should be allowed to remain so as to provide law enforcement officials with information helpful in apprehending and prosecuting criminal offenders. In order to be eligible for a U visa, you must meet the following criteria. You must have been a victim of a qualifying criminal activity, and this crime must have occurred in the United States or violated U.S. law. You have to have useful information about this criminal activity. You, your parent or guardian, must have been or will be helpful to law enforcement in order to bring the perpetrator of this crime to justice. And finally, you are inadmissible to the United States, or you are successful in applying for a waiver using Form I-192, Application for Advance Permission to Enter as a Non-Immigrant. Examples of qualifying crimes include abduction, abusive sexual contact, blackmailing, domestic violence, extortion, false imprisonment, female genital mutilation, felonious assault, fraud in foreign labor contracting, keeping you hostage, incest, involuntary servitude, kidnapping, manslaughter, murder, obstruction of justice, peonage, perjury, prostitution, rape, sexual assault, sexual exploitation, slave trade, stalking, torture, trafficking, witness tampering, unlawful criminal restraint, and other related crimes. In order to meet the requirements, you must prove substantial physical or mental abuse. You must have helpful information to provide to law enforcement, and you must file a waiver of any inadmissibility issues you may have. Certain family members may be eligible to become derivative U visa recipients if the principal petitioner's application is approved. These include your unmarried children under the age of 21, your spouse, parents, if the principal petitioner is under 21, and unmarried siblings under the age of 18. U visa waiting times include the initial processing time of 4.5 years or more. It takes 3 years to get a deferred action approval, as only 10,000 U visas are issued every year. Once a U visa is issued, it is granted for 4 years, but you can apply for legal permanent resident status in 3 years. Human trafficking under U.S. law is defined based on the 2000 UN Protocol to prevent, suppress, and punish trafficking in persons. The elements of the crime fall into 3 categories. Process, which includes recruitment, transportation, transferring, harboring, or receiving of a person. Ways and means include threat, coercion, abduction, fraud, deceit, deception, or abuse of power. And third, the goal includes prostitution, pornography, violence, and sexual exploitation, forced labor, involuntary servitude, debt bondage, or slavery. For example, an adult woman who was promised a job as a nanny and U.S. working papers if she came to the United States, and upon arrival had her passport taken away and was forced to take care of children for very little money, would qualify as a victim of human trafficking. She was recruited and received into the U.S. by fraud, deception, and abuse of power with the goal of forced labor and involuntary servitude. A child who was brought to the U.S. by a parent to participate in taking sexual explicit photographs would also qualify. He or she was transported to the U.S. for the goal of child pornography. Despite a push by Congress to increase the number of U visas available to crime victims, there is a yearly cap of 10,000 U visas. For T visas, the cap is only 5,000, but the cap has never been met. In many cases, those granted a T visa can apply for legal permanent residence immediately, unlike most of those granted U visas who must wait the 3 years. VAWA is a means for battered and abused spouses, and in certain cases, parents or children, to obtain a green card without the cooperation of the U.S. citizen or permanent resident relative who is abusing them. In order to qualify, the following elements must be established. VAWA petitioners must have a qualifying relative to apply. This includes a U.S. citizen or legal permanent resident spouse, a U.S. citizen or legal permanent resident parent or step-parent, or a U.S. citizen child who is an adult. If the qualifying relative is a spouse, you must prove that you were married in good faith, that you live together, and all VAWA applicants must show good moral character. Remember that regardless of what type of visa you apply for, you will need to submit plenty of evidence to show that you are eligible. Also, if your application is denied, you risk being placed in removal proceedings and ultimately deported. So it is advisable to seek the help of an experienced immigration attorney or domestic violence advocate before you apply. If you think you may benefit from a victim-based application, make sure to give us a call for screening at 414-533-5000. Tune in next week for our Next Tip Tuesday.